In early 2000s and around mid 2000s, puts were quite common. And at that time, a promoter called RBI saying that these options change the nature of the instrument from equity to debt. Lo and behold, what followed was RBI saying that these clauses are not valid and started taking actions, in fact, preventing some of the investors from invoking these clauses. We saw an initial example in the D.E. Shaw case, where D.E. Shaw was prevented from enforcing their put against DLF. And I've been told that the joke at the time was that when an investor put, the promoter calls, that is the RBI. And so what then followed was RBI issuing multiple notifications and circulars to the effect that optionality clauses are with assured returns are not permitted. And equally, promoters defaulting on contracts that they had willingly signed on to and relying on the RBI notifications and otherwise to say that these puts with assured returns are not enforceable. Since 2017, we saw the judgments in Docomo and the Cruz City case, which came in. And from there on, we have seen a series of judgments which have come through, and the most recently being the Nine Rivers case, wherein the courts have upheld and enforced some of these clauses.
We're financial investors. We are investing with a very definite time period in which we have to exit, right? So the exit rights need to be very tight. And that's where the put also comes into, the thought process of the rights that you think about as a lawyer. But top of the mind right now for everybody's IPOs. Indian IPO market in the recent time has done well, and that's where the focus for all private equity investors has been in recent years. That's really if you can get that done, and we all start working as soon as we invest to look at what the exit strategy will vis-a-vis an IPO would be. And if the IPO doesn't work, then the best option you have is a strategic sale to another PE or a strategic investor, but basically a secondary sale to one of our peers. And that's traditionally also done well, and so is on top of mind for everybody. I think real industries versus tech is the main differentiation I would give. And let me also say, put is not something we rely on, Ashish, because again, we are control investors. I think it's more a tool for minority investors, but because when you're in a control deal, unless the promoter intends to stay back, or we're actually usually giving promoter an exit and then just keeping them on for their expertise. So it doesn't really work in that scenario that much commercially. And also, for example, in tech, the promoters are a little more uncertain. The business is a little more uncertain. The future projections, the future valuations, cash flow, all of those are an issue. Versus in real industries, heavy industries, infrastructure, you'll have a more structured company cash flows, and the promoter, if he really wants you out, can really cough up the money, and so it makes more sense. And typically in those scenarios, of course, every company is going to be different and every negotiation is going to be different.
I think there is an increasing trend for financial sponsors to be doing control deals. So we're seeing fewer contentious issues than I was maybe 5 or 6 years ago around exit rights. I used to see a lot of drag tag and then failure to have an IPO. Now the IPO market's pretty hot, I guess frothy, but we'll see. And so there isn't a need to enforce them. So thankfully they've reduced, but that doesn't mean that there aren't these cases as we're seeing in the Supreme Court and High Court.
There are cycles.
Yeah, there are cycles.
Wait for the market to go up a little and they'll all come back, unfortunately.
Exactly. Tribunals are enforcing these puts. And very clear trend that we've seen over the past 10 years or so. I think starting with Tata Docomo and before that, there are two ways to do it. One is damages, and the other is the specific performance of the put, so directly enforcing the put itself. On damages, the tribunal turns the put into a money award. So that is what happened in Docomo. That's what happened in EIG versus McNally. These are all cases I think you circulated beforehand, and hopefully our audience has had a time to at least skim them or review them. The latest case this past year has been Nagraj Milandla, I think, where again it was enforced as damages. This distinction is quite important from a FEMA perspective and what the court, how the court views this, and I'll come back to that. But I think the clear trend is that all of these tribunals are enforcing it. And the clear trend then is that these enforcements by the tribunals are being challenged in court on the ground of FEMA violations. And then there's another clear trend there, which is the courts are all upholding these awards on the ground that they do not violate FEMA because it is not a fundamental violation of Indian public policy. They say that the RBI, whether permission is needed or not, is a separate question. And that's where it gets really interesting. What the courts have been doing on multiple occasions, some courts have said RBI permission is not required, but I think most courts don't go into that question. They say RBI permission is a separate issue for the RBI. We will either enforce them as damages or we will grant specific performance. I want to deal with two cases. One is, I think, the Nine Rivers case, which is the most recent, where interestingly it was a specific performance case. So they granted specific performance. The Delhi High Court upheld the award and said there's no violation of fundamental policy of Indian law. It came to the Supreme Court, and the Supreme Court said, even though the Delhi High Court, and in the Supreme Court, they asked for an RBI affidavit. And the affidavit said, even though the Delhi High Court had said this is not an assured return, in fact, it's a negotiated outcome because it's a consequence of breach, therefore it's a negotiated outcome. The RBI said, look, we consider this an assured return. Therefore, even if you go ahead and enforce it, we think it's an assured return, and therefore there won't be permission forthcoming. The Supreme Court dismissed the appeal, upholding the award and saying there's no breach of public policy. I don't know where that went to, given the RBI's affidavit. Maybe you'll have better clarity, but that is a case where there was specific performance that was granted. And if the RBI then went ahead and did not give permission for the transfer of shares, maybe the investor would have been left without a remedy then. Now take a different case, one of the other lines of cases where it was damages that was awarded. Now, if damages are awarded, then there is no question of specific performance. There is a separate question of what do you do with those shares, which we'll come on to later on. But if damages are awarded, then the RBI has filed an affidavit in one of the cases, I think it was Twarit, where, or one of the other cases where the RBI says it's a current account transaction. Therefore, we do not need, the investor doesn't need permission. That seems to be what the RBI's view is in the Supreme Court. But I think the distinction then becomes clear. In cases where the tribunals are awarding it as damages, then it becomes enforceable. The assured return problem still exists, but perhaps less of a problem than if you're awarding it as specific performance. What is the the objective of the put, and how it's going to be enforced? So I think 9 Rivers had this very specifically where they dealt with it, which is the put operating as an assured return, which is the put a guaranteed return to be exercised at any given point of time, or is it an event of default put, where you then negotiate a price and therefore leading to a negotiated outcome? If you take that latter view, if the party has to do step A, B, and C, and if they default in doing step A, B, and C, you go to step D, which is a put, which is a consequence of failure to do step A, B, and C, then the price that you negotiate for the put, even if it be an assured return of 25% or 30% or whatever it is, becomes a negotiated outcome, and therefore not an assured return. And that is really the line of jurisprudence that we're seeing. And we're seeing a lot of courts hold that this is not an assured return at all. Starting with Docomo, right? They're saying it is a negotiated outcome. It's an event of default put mechanism, and you don't even need to go to a short return. But then you come back to the tension that you just mentioned, that if the RBI is treating it as an assured return, then how do you resolve that conflict when there's a court judgment that says it's not an assured return?
The other way that we've also seen many times the tribunals reason this out is by identifying that the put is not purely on the promoter itself, but any nominee of the promoter, any third party that the promoter may identify. And therefore, there is this alternative available to the promoter that he may identify a non-resident buyer, and in which case the transfer will be between 2 non-residents, and therefore no question of FEMA altogether arising in that scenario. And correspondingly, if there is a legal way to perform, there has to be damages for non-performance.
PPS stands for Protective Preliminary Order. In colloquial term, maybe say ex parte emergency order. But ex parte doesn't mean the whole proceeding runs ex parte. So ordinarily the purpose of this is to protect your right of what you're trying to get the relief in the emergency arbitration application in the first place. So if you are suspecting, for example, your shares, which are subject matter of the put option or the exit, that the promoter is going to maybe sort of get rid of or transfer, and you have the evidence that this is going to immediately happen. So the exact relief that you're trying to achieve or get from the emergency arbitration will become futile. You will try and protect it through a protective preliminary order. So you file an application for appointment of an EA with the PPO, and that typically sort of gets within 24 hours, you get that protective order. But this has the timeline of three days at the best, within which you have to notify the other side, and the other side gets an opportunity to come and have it say, and then effectively then the EA would pass an order. So this is an extra tool within the toolkit to be able to sort of safeguard your rights in these urgent situations where you do suspect that the other side will have some sort of a foul play in those cases.
The offer to surrender is made so that you avoid double recovery. If you get paid and you keep the shares, then there's a double recovery question. So you want to avoid the notion that you're going to get paid twice. So you can't keep the money and the shares. And once you've been paid, the shares are, I'm not sure you'd want to keep the shares anyway. You want to exit, so you don't want to be involved in the company anymore. So it doesn't really serve the purpose. This is what has been done in every single case. So in Docomo, payment was ordered on the tender of shares. In the other cases that we've discussed, in most of them, there was a need to surrender the shares. The real question is, who do you give it back to? And here is where there is an interesting gap, because the cases don't seem to provide a clear answer.
Interestingly, it filed an RTI with the RBI and took out all the internal notings of RBI about this case. And they produced it before the court. Even in the internal notings of RBI, the RBI officers were writing to each other saying that this is not an open-ended assured return. This only protects the downside 50% of the invested amount. And therefore, we should be facilitating the honoring of this fair agreements, these type of fair agreements. They rely on these RBI's own internal notings in Tata Docomo to suggest that this was again not an open-ended plain vanilla put option with a short return, and therefore, the court also held that the question of remittance is separate, and therefore RBI. First of all, they say that the RBI does not have any standing to come before this enforcement court and resist the enforcement. And And then they say that this is not really in a short return and therefore not in violation and therefore not in violation of FEMA and therefore what the concept was. This was appealed in Supreme Court under a special leave petition, and the Supreme Court then directly implemented RBI. They in fact called RBI and asked RBI point blank to come before the court and explain their position about the whole situation. The RBI says two things in their affidavit. We've seen those affidavits. We've been in close quarters with some of these cases. The RBI takes these two positions. Number one, the RBI says that the agreement that was entered, which provided for an put option within a short return, was of course not permissible under FEMA. However, because this award is a damages award and it is in that sense a money decree, it has changed its color. The transaction now becomes a current account transaction for which no permission is needed. So that was the position in GP. A few weeks back, I was speaking with a judge who's been at on the arbitration roster for a long time, and the discussion was centering around how it has almost now become public policy of Indian law to enforce awards. So how do you balance that public policy? You keep coming up with these counter arguments of it's violating FEMA, it's violating XYZ, and that's not public policy. But enforcing arbitral awards has also now become a public policy of Indian law.
I think enforcing a buyback has a lot more statutory controls that you need to look into, right? So with a buyback, it is corporate law driven. There are issues under various corporate laws here. We'll be discussing India, so the Indian corporate law will have various requirements that need to be strictly followed, and if they're not strictly followed, then they will lead to various issues. The key difference for our audience, I know we have a diverse set of audience. I mean, put as a contract, and it binds a person. So there is a promoter or a third party, and then you have the investor who's selling shares to that promoter or third party, and that's how a put really operates in more simplistic ways. Whereas a buyback is quite different, right? So it's a company buying back its own shares, and in India there are legal ceiling limits within which you can operate a buyback. And I think that's where you see the real difference. It is a mechanism that we see. To be quite honest, I don't see it go into disputes as much as I do puts, but that is for the reasons that we've discussed here. I think the short return issue does arise. The FEMA issue arises even in the context of buyback. You will be better placed to discuss that. Those issues do arise. But in my experience from the vantage point that I said, I see more put disputes than buyback disputes.
We have come to the end of our first of the three-part masterclass series. I would like to thank everyone. I noticed we have had tremendous participation and for people who have stayed through right up till the end. So thank you so much. We'll soon be releasing details of our next session in this series, and we would hope that you would join us there as well. Thank you. Thank you all.